Good morning, good afternoon. Thank you for joining today's webinar hosted by Whitcomb Solinsky PC. My name is Sherry Hugh Smith, and I'm the Chief Marketing Officer for the law firm. Today's webinar is titled Intellectual Property and DoD Contracting, Asserting, Marking, and Justifying Restrictions on Technical Data. Before we jump into today's webinar, just a few housekeeping items. If you have any questions throughout the webinar for our presenter, please list your question in the GoToWebinar dashboard where it says questions, and I will read your question aloud for Ann to answer. If you have any technical issues, please list your issues also in the webinar dashboard under questions, and I will figure out how we can help you. I have on your screen now the disclaimer for today's presentation. Just go ahead and read that really quick. A little information about who we are, Whitcomb Solinsky. We are a Colorado-based boutique law firm. We were founded in 2012, and we do have a national reach. We focus on small and medium-sized businesses, as well as veteran-owned businesses. We are a verified service-disabled, veteran-owned small business, and more than half of our attorneys come from military backgrounds. Again, we are a boutique law firm with about 16 attorneys and 15 support staff. We are licensed in about 9 states in the U.S., but again, we do have a national reach for anything related to government contracting, trademark law, employment law. We also have several specialty areas aside from Whitcomb Solinsky PC. We have the Rocky Mountain Disability Law Group, and we focus on Social Security disability benefits and veteran disability benefits. We have Beer Law HQ. We focus on craft breweries and any issues related to the craft breweries. And then we have the Veterans Advocacy Law Group, which focuses on veterans and veteran-owned businesses. So with that being said, we will jump into today's webinar, again, titled Intellectual Property and DoD Contracting. And our speaker today is Ann. Ann is one of our senior attorneys, and she's responsible for intellectual property and data rights. She has more than 35 years of professional legal service, and she focuses on IP, government contracts, and patent law throughout her career. She's worked extensively with the U.S. government on government contracts and knows the intricacies of federal procurement actions. Her expertise in FAR and DFARS, it further aids in her expertise in government contracting. With that being said, we'll hand this over to Ann. Ann, let's go.
Thank you, Sherry. This presentation is going to be more of a primer for those of you who are not familiar with the peculiar rules and regulations that apply to technical data and software rights involved in government contracting, more specifically DoD contracting. So with this discussion session, there will be a brief description of the main types of intellectual property, DoD policy regarding data and software rights, asserting data right restriction, that is, asserting by the would-be contractor or government contractor on how to assert restrictions on what the government can do with the data that the contractor delivers to the government. And when it comes time to deliver the data, how to market with authorized markings, and how to justify and validate the restrictive markings when and if challenged by the contracting officer. Well, the next two slides will have a brief description of the 4 main types of intellectual property, all of which can be involved in government contracting. As many of you already know, patent is what most people think of when they think of intellectual property. Patents is an exclusive right for the patent holder to exclude others from using, selling, and making the device or process that is the type that is taught by the patent during the life of the patent. Is it published? Yes, of course it is. An issued patent is a public document. Anyone can get a copy of it from the USPTO website. And the subject matter of a patent can be new and useful device, drug formula, which would be usually chemical formulas, and new tools or even software. A patent has to be on an invention that is new and useful. A process, it can be a process, machine, or composition. And it must be non-obvious over the existing prior art. The second category that most people think of when they think of IP is copyright, which covers the right of the author on original works and artistic expression affixed in a tangible medium. It is usually the material that is covered by the copyright is usually published, but it doesn't have to be. And as many of you know, copyrights exist in books, musical compositions, paintings, movies, sculpture, and even choreography. Now, one thing to mention here is that no copyright exists in works produced by the US government. That is statutorily true. So that a piece of work that would otherwise be copyrightable, but produced by a government employee during and within the scope of his government employment is not eligible for copyright protection. In fact, the only way that the government can own copyright is if a contractor or private individual assigns its copyright to the government. And the copyright is created or comes into existence the moment the work is created and extends for the author's life plus 70 years. The next slide will describe the two remaining well-known categories of IP. Third one is trademark, which can be a word, mark, color, pattern, even sound that is used in commerce. And it is published. It is known to the public. Some examples are Wikipedia, Nike, Birkin handbags, and even the phrase 100% that bitch belonging to Lizzo. She was successful in registering this trademark in February 2023. The function of a trademark is to distinguish the applicants or the owner's goods and services from those sold or manufactured by others. So it's a source indicator, indicating where the goods or services come from, and it involves a goodwill and good reputation of the trademark holder. A trade secret is the fourth main category of IP, and that covers any information giving the possessor of the trade secret advantage over others who do not have the same information and in the marketplace, and it is not published. Trade secret must stay secret in order to be valid. A famous example is the Coke formula. Even a customer list of a business can be trade secret if it gives him commercial advantage of others. What I need to mention is that the technical data and software rights that I will be talking about in greater detail later on in this presentation is really a version of the trade secret protection, because when you're talking about asserting, marking, and justifying restrictions of what the government can do with the data that you deliver to the government under a contract, basically tries to keep it as non-public as possible in order to give you the competitive advantage of others. So it's a government unique form of trade secret protection. So intellectual property rights in general as stated in the next chart, basically is a bundle of rights that is applicable to technical data or computer software that are required to be delivered under the government contract. Now, all of these things that I'm going to say about technical data and computer software and what markings need to be placed on it and how to assert all apply only to technical data or computer software that are required to be delivered to the government under government contract. Now, if you're talking about a piece of technical data that you are just willing to provide to the government, even though it's not contractually required to be delivered, none of these marking requirements or asserting requirements will apply to that. The government basically needs to make sure that the technical data or computer software that it wants to have in its possession needs to be indicated clearly in the contract as required deliverable. And they usually use the form 1423, DD form, within the DoD that is, DD form 1423 to make the requirement contractually clear. One thing that needs to be emphasized is the title of ownership in the technical data rights and license. Ownership of rights allows the owner to license it out and sell it, and either for license fees or for free, depending on what the owner wants to do. And the license is something less than the ownership. Now, depending on the scope of the license can come very close to the ownership, but it's not the same. It's something less. And when dealing with government contract, technical data and software rights, especially within DoD, we're talking about license. The DoD hardly ever wants to have title of ownership, technical data rights. All it wants is some form of license, depending on what the government needs to do with the technical data or software, will determine what type of license it wants to get and needs to negotiate, if necessary, with the owner of the data. And the data owner is the creator. That is the contractor that created the data, even if it is under government contract and funded wholly by the government. The owner is the contractor. Now, depending on how much money the government put into the creation of the data or software in question, will determine how wide a scope of the license the government gets. And that is going to be discussed in several charts later. So policy stated on the next chart, the DoD policy is to acquire only the technical data and software documentation and rights in these items that is necessary to satisfy agency needs. Meaning that the government's policy is not to buy or license rights that it does not need, that is much more than what it needs. It's always what the government needs, necessary to satisfy its requirements. That is the policy. And another policy statement that is important for the contractor to keep in mind is that the offeror offering on an RFP on a government contract that requires the delivery of certain technical data or computer software, such offers are not required to sell or otherwise relinquish to the USG any rights in technical data or technical data related to the item component process developed to private expense. So if you're a government contractor and you developed a certain widget at your private expense and the government requires delivery of technical data pertaining to that widget under the contract, if you accept the contract, you will have to deliver because that's a part of the contract performance, but you don't have to relinquish your rights in the data more than what the government is already entitled to. And what the government is entitled to will be discussed in a couple of charts. But what the rights offered, what the rights offered by the contractor can be evaluated during the selection process, which means the contractor may not be required to offer certain level of rights in order to be considered responsive to a solicitation or as a condition for award. Contractor can always voluntarily offer additional rights, and that may count favorably in an evaluation for the selection process. The applicable regs in a DoD contract applying to data rights or software rights are in DFARS 227.400. So basically what it says is that even though DoD is part of the federal government, when it comes to dealing with rights in technical data and computer software, the DFARS applies, not the FAR. So this part specifically says that DoD activities shall use the guidance in subparts 227.71 and 72, which are parts of DFARS, and not FAR, not the FAR. And the next slide talks about the differentiation between commercial and non-commercial. And this is critical when you're talking about technical data and computer software rights, because all the asserting requirements, marking requirements, and justifying requirements that are listed in the DFARS apply to non-commercial technical data and non-commercial computer software. Now, there is a clause that does deal with what government rights exist in technical data. Does address commercial technical data, but specifically to keep in mind with the DoD contracts is that there is no provision stated in the DFARS or DFARS clauses for what government rights exist in commercial computer software. Basically, commercial computer software, if and when required by the U.S. Department of Defense, the DoD gets the rights and obligations, the rights that are provided by the commercial software vendor to the general public. So the government does not acquire any particular rights in commercial computer software just because it's the US government. Now, when we're talking about non-commercial technical data or non-commercial computer software, the government is entitled to certain rights just because the buyer is DoD, and these rights are listed in the DFARS that I just mentioned in the previous slide. So that's why, for a contractor to be able to say, well, the government or you are entitled to only the same rights that our public, commercial customer gets, and no more, you need to be able to say that the computer software in question is commercial computer software, meaning that it was developed usually at private expense by the vendor or the owner of the rights in the software, and customarily used by the general public and by non-governmental entities for non-governmental purposes, and has been sold, leased, or made available to the general public. And usually such things have commercial licenses with terms and conditions listed there, and those terms and conditions would be the same conditions and terms that apply to the U.S. government when it gets when it acquires commercial computer software. So next slide talks about technical data, and we're here from this point on, when I say technical data, I mean technical data pertaining to an item, component, or process that's been developed for the government and it's not commercial, meaning it's not commercially sold in the to the general public, but this is a most likely item, component, or process, frequently referred to as ICP, developed under government contract with government statement scope of work. So when we're talking about technical data, we're talking about recorded information of a scientific and technical data, including computer software documentation. The term does not include computer software because it's got its own separate definition, or cost or pricing information or data incidental to contract administration. So, you know, I mean, this is the definition that that is lifted right out of the DoD DFARS, DFARS 252.227-7013. It's a long and complicated clause that is required to be included in all DoD contracts that under which technical data will be required deliverables. So when we talk about technical data, we're talking about technical data pertaining to the ICP, item, component, or process. For example, engineering drawing of a device is technical data. The device itself is not technical data. Okay, that needs to be kind of kept in mind. And a lot of people, even within the government, get confused. They equate a scientific instrument with technical data. Now, the instrument is not technical data because it's not data, it's a hardware item. But a user manual on how to use it may be technical data because it's data, not hardware item. The next chart talks about computer software and documentation. Again, definition. Now, computer software is defined as computer programs, source code listings, and so forth. These are also definitions that appear in DFARS 252.227-7014, which is required to be included in any contract with DoD where the government is requiring the delivery of software as a part of contract performance. But flowcharts, formulae, and related material that would enable the software to be reproduced, recreated, or recombined, but does not include computer database or computer software documentation. And the documentation is defined by DFARS as owner's manual, user's manual, and so forth. And regardless of storage medium, that explains the capabilities of the computer software. The next chart talks about data rights. Now, as I mentioned earlier, data rights are license rights, not ownership rights. License rights that are unique to the US government under government contracts. A unique version of trade secrets. And these data rights talk about the government's rights to modify, reproduce, perform display, or release or disclose the data in question. Now, the DFARS clauses that are included in the contracts for data, technical data or computer software only talk about what the government can do, what the government rights are regarding this technical data and software that are required to be delivered to the government. These clauses say nothing about what the contractor can do. Basically, since the contractor, if it's created the technical data in question or developed the software on the government contract, since they are the owners, they can do whatever they want with them. There are no restrictions on what they can do with the property that they own. So these default clauses dealing with data rights and software rights only address what the government rights are. Often, I've been asked, since in a case when the government pays the entire cost of developing an ICP, item, component, or process on the contract, and the contractor performs that development and develops the researches and manufactures a certain widget on the government contracting, and the government paid 100% of the cost of it, frequently even government employees will think, well, we paid for the whole thing, therefore we own the technical data that pertains to that ICP, and we can keep the contractor from using it for itself or selling it to anybody else. And that is not the case. Excuse me. That is not the case, because even if the government paid the entire cost of developing such an item, the ownership of the technical data rights pertaining to that item belongs to the contractor. And as the owner, the contractor can do anything it wants with it. Now, there are certain provisos. The contractor, even though it's the owner of such data rights in the technical data or software, as the case may be prohibited from disclosing it to certain individuals under export control or government security related regulations. So intellectual property wise, they may be able to do whatever they want, but there are other regulations that pertain to disclosure of certain information that may prohibit the contractor from disclosing its own data, technical data. Export control is one of the main regulations or laws that may get in the way of the contractor disclosing its property, if it is government, if it is technical data, sensitive technical data. There are certain rights in technical data or computer software that the government gets regardless of delivery of the data or computer software. Basically, this is saying that as soon as the government signs the contract with the contractor, and the contract requires a delivery of certain technical data as part of the contract performance, there are certain types of rights that the government gets, whether it is actually delivered or not, because sometimes the contractor will resist delivering certain technical data, thinking that they are giving up rights to the government, or even if the government promises to keep it confidential, they don't quite trust the government to do that. And in order to make sure that their trade secret, in this case technical data, is kept safe, they just refuse to deliver it. Now that would create a problem of non-performance of the contract. That is, if the contract required delivery of certain technical data and the contractor fails to deliver for whatever reason, then the contractor is failing to perform an integral feature of the contract performance, and that could subject the contractor to termination for default, for example, for non-performance. Now, as I said, the government acquires certain rights regardless of delivery of the technical data or computer software in which it has rights, but the government must also require the delivery of these data or computer software as a part of the contract performance, because if the government fails to make it a part of contract performance, then the contractor obviously does not have to deliver if there's no delivery requirement. So there can be a situation where the government has certain rights in technical data or computer software, but cannot effectively exercise those rights if it never got the delivery of the data or software in question. So the government, of course, needs to make sure that the contract it signs clearly indicates and requires the delivery of whatever data or software that it needs to have in its possession. Now, finally, the categories of rights that the government gets. Unlimited rights. The government acquires unlimited rights in technical data, non-commercial technical data, of course, developed exclusively at government expense. This is almost as good as title of ownership, but it's something less. But what unlimited rights allows the government to do is to use it for whatever purpose it needs, disclose it, and display it without any limitations. That means the government can disclose unlimited rights technical data to a competitor of the original contractor that developed the technical data. And it can do so because the government paid the entirety of the cost of developing the item, component, or process to which the technical data pertains. The next slightly narrower scope of rights is government purpose rights. That can exist either in non-commercial technical data or non-commercial computer software. Sherry, I'm still on the previous chart. Now, government purpose rights, referred to as GPR, the government gets such GPR if there was mixed funding of the development of the computer software, non-commercial computer software, or the item, component, or process to which the non-commercial technical data pertains. Mixed funding means some of the expenses were paid by the government and some expenses were paid by a private entity, usually the contractor that developed the technical data or computer software. The government can release.
And I'm going to interrupt the audience now.
I'm sorry?
And we're having some
Yes?
technical difficulties. We're having some technical difficulties on our end, and we're asking for the audience to just please be patient. Our technical difficulties is something that we're not able to control on our end. The audio it keeps going in and out. So we'll do our best to manage it. It looks like everything is working right now, but please be patient with us as we work on this, everyone. Thank you. And you can continue.
Okay. Thank you, Sherry. As I said earlier, unlimited technical data can be disclosed to anyone by the government. GPR data can be disclosed by the government for government purpose, meaning to a third party that is other than the original developer of the data or software, the third party for government purposes. And the government purpose is defined by the DFARS as any transaction to which the United States government is a party. And that includes another contractor or another would-be contractor who needs access to this GPR data in order to formulate its offer to the government. But the recipient of such a GPR data or software must sign a non-disclosure agreement, that limits what it can do with it and promising to safeguard the data. Limited rights data is technical data pertaining to an item, component, or process that's been developed exclusively at private expense, meaning that the government did not have any contribution of funds to the development of the item. And with such data, the government cannot disclose it to anyone outside the government, but can use the limited rights data within the government. And by within the government, it means not just the DoD, even if it is DoD contract, but within the entirety of the US government. And that's a large entity, as you know. Limited rights term is applicable only to non-commercial technical data. Now, for non-commercial computer software, we use the term restricted rights. And that means that software in question was developed exclusively at the private expense. And once again, there is no third-party access, meaning that the government cannot disclose it to anyone outside the government. And another category of rights, either in TD or CS, that is coming into more use, is specially negotiated license rights. And that the terms and conditions of negotiated license rights are, of course, set out specifically in that license. So in order to know what the government can do, what the government's rights are in such a license, negotiated license rights, is to look at the license itself. Now, unlike this license rights, the four rights of category listed above, the unlimited, GPR, limited, and restricted, you know exactly what the government can do with these rights by looking up in the DFARS clause, because the DFARS clause defines what limited rights means, what GPR means, what limited means, and what restrict means. These are default categories. But if the government needs do not or if the government needs will not be conveniently met by one of these default rights categories, then it should negotiate a specially negotiated license rights and purchase only the rights that it needs. The next category, the next chart talks about the first step that the contractor needs to take in order to protect its confidential technical data. So if a certain piece of technical data is required to be delivered as a part of contract performance to the DoD, then the first thing that the contractor needs to do after verifying that that piece of technical data is indeed a required deliverable is to make an assertion of restriction. That is, the contractor says to the government, yes, I will deliver that piece of technical data as would be required under the contract, but there are certain restrictions we are placing on you, the government, as to what you can do, how you can use this particular technical data. So this is a form of a table that you can find in DFARS 252.227-7017 during the solicitation stage and submitted as a part of your offer. So here are some examples of what you can list and how to list. And list technical data and identify the underlying ICP, that is the ICP to which the technical data pertains, or identify the computer software, one item per row. And one example I have here is design drawing for T1 seeker for X missile. The rights category asserted by you is limited rights. And the reason that you can, you feel you can assert limited rights, which really limits what the government can do with that data, is because you developed the seeker entirely at your private expense with no government funding. And the name of the person asserting the restrictions is an officer of the contractor who has authority to bind the contractor contractually. The next item asserts a software called alert, and you assert restricted rights, which also very much limits what the government can do with that software as far as use, disclosure, and modification and so forth concerned, because it was developed entirely at contractors' private expense or subcontractors' private expense. meaning there was no government contribution to the funding. The third item is lens cover for the seeker. The government is limited, gets only limited rights because the contractor developed the seeker, the lens cover for the seeker entirely at its private expense. But something is wrong with one of these items on the assertions list. And if an assertion list like this is submitted as part of your offer to the government, it will come back asking you to make the correction. And where does the correction need to be made? Anybody wants to take a guess? Well, okay.
No, yeah, no answers yet.
Okay. Just maybe a minute or two more. Well, I'll just tell you.
Okay.
Yeah, the last item is not asserted correctly because lens cover is not data. It's an item. So the technical data pertaining to that lens cover needs to be identified, as well as listing lens cover as the item in question. So the chart for asserting is only for listing the technical data and the underlying item. The item itself with no associated technical data is not proper assertion. Continuing the next chart with the asserting, when you assert restrictions as to what the government can do or what the government rights are in any piece of technical data, you're advised to assert at the lowest practicable level at which you can substantiate the basis for the assertion. So, looking at this example, let's say that, the private expense supported the development of the wings. Now, if you assert the government restrictions on the level of the entire missile here, you will not be able to substantiate that you developed at your private expense the entire item, but just the wings. So the contractor gets to choose which particular item it wants to assert at the level. Because if you include your restrictions on the whole thing and you cannot substantiate with documentary evidence, then you get to lose your asserted rights, meaning that you have substantiating documentation only for the wing development, but you for some reason decided to assert restrictions on the entire missile system. And if the government contracting officer asks for substantiating documentation that supports your limited rights assertions for the whole thing, because you asserted on the whole level, and you're unable to provide the documentary evidence, then this will be unsubstantiated assertions, and you may end up actually losing your asserted rights even on the wings, which you had the right to do if you had chosen to assert only at that level. So it is critical for the contractor to assert at the lowest practical level at which you can substantiate by being able to produce substantiating documentary evidence. Now, after you submit the assertions list as part of your RF proposal in response to an RFP, and let's say that you got the contract, the next thing to do is place appropriate marking on the technical data before you deliver, because delivery is a mandatory part of contract performance on the contract that you just got. But before you deliver, make sure you place the appropriate marking on the data, because if a required deliverable data is delivered with no marking, whether by intention or because inadvertence, oversight, that unmarked data is being delivered to the government with unlimited rights for the government. Now, it's very, very hard to go back later and ask for permission to place a marking on a piece of technical data that has already been delivered with no marking, because the government has assumed that it's unlimited rights, and the government may have already disclosed it to somebody, like your competitor, for example. And trying to mark something that was previously unmarked can require additional conditions and requirements and permission of the contracting officer to mark it later. So make sure that whatever you asserted restrictions on by submitting assertions list is appropriately marked before you actually deliver it to the government, and use only conforming markings. And we're going to go a few charts later on the conforming marking language, because the conforming markings are set forth in the DFARS regulations. The exact wording and format are listed in the DFARS, and use those, meaning that you're not encouraged to do any creative writing in coming up your own marking. Use those that are set forth in the DFARS. And those authorized markings are set forth in the 7013 paragraph F for technical data and 7014 paragraph F for computer software. And these markings should appear on the technical data or computer software listed in an assertions list that's been incorporated into the contract. And if a technical data that is delivered, that is required to be delivered, will have some kind of a restrictive markings on it, but the technical data itself comprises multiple pages, you are to mark only the restricted portions of each page, not the whole thing, unless the whole thing qualifies for restrictive markings. If you decide to get creative with your restrictive marking language, it will be considered to be non-conforming marking, and that can be subject to correction and or removal by the government in accordance with the DFARS provision set here. And usually the government will give you letters, what we call the 60-day letter, which allows you 60 days to make the correction and put remove the non-conforming marking and put the correct conforming marking. So if you take no action within the 60 days, then the government has the option of correcting it for you at your expense, or it may also decide to remove the non-conforming marking and not put any markings on it at all. If technical data ends up being unmarked because the non-conforming marking was removed by the government and not replaced with anything, then that technical data now becomes unlimited rights for the government, because now it's unmarked. So it really is in the interest of the contractor to respond to such a 60-day letter and correct the non-conforming marking and place the appropriate conforming marking. Words such as proprietary, company confidential, etc. are prime examples of non-conforming markings. And if you put restrictive marking, even if it is conforming language, on technical data or computer software on which no assertions have been made by the contractor before, then any such marking would be considered non-conforming marking. Now, copyright marking in proper form is okay, even on unlimited rights data. The copyright proper form follows the format listed in 17 U.S. Code 401. So, continuing the conversation regarding appropriate marking, the next chart describes what the appropriate marking is for unlimited rights data. Currently, there is no required data rights marking to indicate that something is unlimited rights. Basically, technical data that is required to be delivered and has no marking whatsoever when it's actually delivered to the government is considered to be unlimited rights for the government. Now, even on unlimited rights technical data, you can put copyright notice. That does not get in the way of the government using the data for, with its unlimited rights. But because there's been a lot of confusion on technical data that is delivered with no restrictive rights marking at all, that is confusion mostly on the part of the government employees, there's been a proposed rule to create and require a new unlimited rights marking for technical data and computer software that is furnished to the government without restriction. And the confusion arises from the fact that, when a government employee sees a piece of technical data that's got no restrictive marking, they often ask, and no restrictive marking, but has copyright marking on it, as the contractor is allowed to put. The government employee often is confused and asks, does this copyright notice on this marking get in the way of the government using it in any particular way? Or did the contractor neglect to put or forget to put some kind of a restricted marking on it? So the proposed rule to require unlimited rights marking for technical data and computer software, rather than just delivering the TD or software with no marking at all, will probably reduce the level of confusion on the part of the government employee. And also assist the contractor in deciding that it is granting the government unlimited rights intentionally, not unintentionally by just forgetting to mark it or forgetting to put any kind of rights marking. The next few charts are copies of the conforming markings that appear in the DFARS. Unlimited rights, as I said, there is no current marking for it. You just deliver the technical data with no marking whatsoever. And that indicates that you're delivering it with unlimited rights for the government. But for GPR, here's the marking that is conforming marking that you should use word for word. And the next chart shows the limited rights marking that should be used word for word. And the next one, special license rights, that is negotiated rights. This language should appear on the technical data that is subject to special license rights. And as I briefly mentioned, justifying earlier, if and when the government contracting officer asks for substantiating documentary evidence to justify your claim of private expense development, then you need to produce the documentary evidence. And the burden to keep and maintain the record sufficient to justify your claims of any kind of restriction is entirely on you, on the contractor. You must create and maintain records sufficient to justify the validity of your claimed restriction and be able to produce and present it to the contracting officer if and when he should ask for it. The 701,
And
7037 and 7019 are challenge provisions. That is when the government actually challenges the validity of your claimed restrictions. And these clauses set out the step-by-step procedure of what the government needs to do and what the contractor that is being challenged needs to do, and the time limits within which to take these steps. And
we do have
hello?
a question.
The
Can you hear me,
yeah,
Ann?
yeah. The general trade secret laws that these
All right, we do have one. We do have.
You have a question? I'm
Yes,
sorry.
we do have a question.
Okay.
The question is the question.
You're drifting in and out.
Can you hear me,
I cannot hear you. Is this something that we can respond to in a
For some reason, our screen. Yeah, our screen has slowed down. I'm not sure what is. Yes.
Okay, this is something we can answer later, maybe?
Yes, Ann, we
Because
can respond. Yes.
okay. Okay, I'll just proceed with the remaining two.
Yes.
The general trade secret laws, now I'm getting out of the DFARS arena. Just briefly, general trade secret laws. Until recently, the secret law protection, trade secret law was governed by, state law. Most states have adopted the Uniform Trade Secrets Act, which is a model act developed by the Uniform Law Commission, a nonprofit organization that defines trade secrets and describes claims related to them. But in May 2016, President Obama signed the Defend Trade Secrets Act, which is a federal civil trade secrets act that gives one the right of action to file suit in federal court in order to protect its trade secrets. But the DTSA does not preempt state laws. And the next to the last slide talks about continues the trade secret law generally. There are Federal Economic Espionage Act, which has criminal penalties for intentionally disclosing a trade secret. Economic espionage for or to foreign entities, and theft of trade secrets that is not for or to foreign entities. And the one that is really important that is applicable to the government employees is 18 U.S. Code 1905, which says that the USG employees are prohibited from disclosing company proprietary information that he gets within the scope of his employment under threat of criminal penalty. And this 18 U.S. Code 1905 is the reason why U.S. government employees are not to sign separate NDAs presented by contractors. The reason specifically being the government employees are already bound by the obligations set out by this 18 U.S. Code 1905. U.S. government employees, therefore, does not need to sign a separate NDA. And that concludes my presentation, and I'd be happy to respond to questions in email. Unfortunately, the sound doesn't seem to be very clear. For me to hear, it seems to go in and out. But we'll be happy to answer your questions that you submit. Sherry? Sherry, I believe I'm done with my presentation.